The first meeting of the 2024 interim session for the Interim Joint Committee on Families and Children. And if the clerk would please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong. Here. Senator Elkins.
Present.
Senator Girdler. Senator Mays Bledsoe. Senator Meredith. Senator Tishner. Senator Webb. Senator Westerfield. Senator Wise. Representative Baker. Representative Kleins.
Here.
Representative Decker.
Present.
Representative Dietz. Representative Elliott. Representative Fleming. Representative Gooch. Representative Rayburn.
Here.
Representative Raymond.
Here.
Representative Riley. Representative Rorks. Representative Stalker.
Present.
Representative Wilner. Representative Wilson. Co-Chair Heverin.
Here.
Co-Chair Carroll.
Here. We do have a quorum duly authorized to conduct business. Do we have any members who are new for the interim to this committee? House or Senate? I know Senate, I don't think we have any, but House. Introduce yourselves, the ones that are new, please.
Sure. I'm State Representative Sarah Stalker. I represent the 34th District in Jefferson County. And I'm ecstatic to be able to join this committee. So thank you so much.
Welcome. Is that it? Okay. We're going to jump right into the agenda. We're going to start with item number 3. We have the regs on the agenda. I want to get those out of the way. And these regs have been referred for review. And do any members have questions on any of these regulations? Seeing none, the referred administrative regs shall be considered reviewed by the committee. Presentations today, and I thought this was a good place to start for the interim in a thorough discussion on the foster care and adoption process. And I know many of you all, like me, you get regular calls from people who are providing foster care, many that are providing in hopes of adopting the child at some point, and a lot of struggles that they face along the way, and how the system's set up, and the repeated times that maybe a child is placed back with a family only to go through the same cycle over and over again. And it's touching sometimes to hear some of these stories and what families go through to finally get to the point to be able to adopt a child. And I get the other side of it too. I get the family preservation side of it, and so that's really what this discussion is about today, and hopefully we can kind of do a broad overview and then kind of focus in on some particular areas related to this topic, and so that's kind of the goal today. We are going to start with DCBS, and Commissioner, if you would please come forward. And I want to thank you both for being here today, and would ask if you would please introduce yourselves for the record, and you have the floor.
Thank you. My name is Lisa Dennis, and I am the Commissioner of the Department for Community-Based Services.
Hello, and I'm Melanie Taylor. I'm the Director in the Division. Is it on? Okay. I'm the Director in the Division of Protection and Permanency at DCBS.
All right. Melanie's going to trust me to be our clicker today, so wish me luck.
Better than me, for sure.
Again, thank you for the opportunity to be here today to talk about foster care and adoption within Kentucky. The mission of child welfare in DCBS. Our primary and first and foremost mission is to ensure safety for children and protect them from abuse and neglect. And we do that. We do that with collaboration with our community partners, which includes biological families, foster adoptive families, court system, other professionals such as physicians, law enforcement, teachers, and et cetera. When we are unable to mitigate safety concerns and a child needs to enter out-of-home care, foster care becomes an option. It's oftentimes the option. And foster care is meant to be a short-term placement in which we are working with our partners that we identified here on this slide and others to reunify children with their birth parents whenever possible. Our mission also, again, talks about DCBS and prioritizing and reunifying children with their biological families once we feel as if those safety concerns have been mitigated and it is safe to do so. And 75% of children are returned to their birth parents or are placed with relative and fictive kin. And of that 25% that are not able to be reunified with their biological families, the majority of those, approximately 80%, are adopted by their foster parents. But we want to be clear, DCBS is not an adoption agency. We utilize foster care and we work and partner with our foster parents to support the goal of reunification. And when reunification is not possible, though, we do consider foster parents for adoption. And here on this slide, you see our out-of-home care trends. And when we talk about out-of-home care, we're talking about children that have been removed from their families, been removed from their homes, and oftentimes removed from their communities and other supports. And again, here you see our trends beginning in March of 2016 through June of 2024. And so as of March of 2016, we had 7,893 children in out-of-home care. That peaked in March of 2020 with just over 10,000. And then as of June, we currently have 8,170 children in out-of-home care. And you see that other number on the screen, that 6,739. And that number is important to talk about because of that 8,170 children that are in out-of-home care today, 6,739 are in non-familial or what we call traditional foster homes. And that's, we want to talk about that in the landscape of out-of-home care to highlight some changes that the department has made. So in 2019, we implemented our relative service array, which created a clear pathway for relative and fictive kin caregivers to become approved foster parents. Prior to that, the data you see on this screen is looking at children that were in that traditional foster care population. So beginning in 2019, when we implemented our relative service array and began working more proactively to help support relative fictive kin caregivers in this space and to be approved as foster parents, we began having data that looks at our out-of-home care population differently. So of that 8,170, again, 6,739 are in those traditional foster home placements, but just over 1,400, getting close to 1,500 now, children that are in out-of-home care, that are in custody of the cabinet, are in relative and fictive kin care. And that's really important because we know that when children need to be removed from their biological families and we can place them with relative and fictive kin caregivers, we are reducing their trauma and which results in better outcomes for children long term. And we'll share here a little bit in our presentation some exciting changes that we're making to really help support relative and fictive kin caregivers even more in this space. And here on this slide, you see what we're looking at is what percent of need is met for foster homes within our system. So currently we have 8,170 children in out-of-home care, and we have 4,555 both public and private foster homes that are available to accept placements. And on the chart, you see the different categories broken down by age, and then you see the percent of need met at the end. And there's overlap. There's overlap within these categories of age. So a foster parent may may want to be considered for placement for children of just birth to 5, or they may say, I want to be considered for the ages of children of ages birth to 11, or they could say any age or any combination of the three. And that's why you see that we have we have more than 100% in those in the age categories of birth to 5 or 6 to 11. And you also see that we have an unmet need for foster homes. We need more foster homes that are willing to accept children that are older, in that age group of 12 to 21. All right, so I am now going to let Melanie talk with you about our expectations and approval process for foster and adoptive parents.
So here's what you see on this slide talks about Kentucky FACES, and FACES is the Foster Adoptive Caregiver Exchange System. We started working on Kentucky FACES about 5 to 6 years ago, and what FACES did for us was really automate the foster care approval and inquiry process. So now we have a system that is available for a prospective foster parent, somebody who is interested in foster care, or somebody who is going through the approval process can set up, can do an inquiry on KY FACES. They can set up a meeting with a recruitment and certification worker to discuss what foster care and adoption is. And for foster parents or prospective foster parents who are going through the approval process, they can have an account, they can register for trainings, they can see in a graph or a chart on where they are in their approval process. And current foster parents can also have that account and use it for ongoing trainings and additional communication, forms and things that need to be signed. So we have been very excited about KY FACES, and it has really improved particularly the speed of that process and how prospective foster parents can put in an inquiry and start that approval process. The next slide talks about training requirements for non-familial foster homes, which are foster homes who are not related to the children that they will be getting into their home. Typically, those children are almost all of the time are unknown to the family. So you get a placement of a child who comes to live in your home and they are a stranger. They were not known to that family before that. This shows what those training requirements are. We do use a national training model that is used for all DCBS public agency approvals for or training requirements for foster homes, and it is used with some of our private agencies who recruit and certify foster homes as well. A little bit deeper into the foster home approval process, you can see here that there is a summary of some requirements for the process, including some home visits. There's an application, questionnaires, health information, verifications, financial statements that have to be done. We also, in Kentucky, have a fairly extensive background check process, which you can see there on the screen, where we utilize Kentucky State Police. We do a CAN, a Child Abuse and Neglect Registry check, an FBI fingerprint check, and also, of course, the Sex Offender Registry check as well. This slide shows what our foster parent survey results have been. So we have been doing foster parent, particularly with DCBS or public agency foster homes, for quite some time. This time, so with our last survey, we did include, so these results include private agency foster homes, and we sent the survey to them as well as to our public agency foster homes, which are DCBS foster homes. And here you can see some of the feedback that we got from those surveys. A couple of things to point out. One is that foster parents did say that the process was much quicker now, and I think that a lot of that is contributed to KY FACES and how a lot of that process is automated now. And you can also see the last bullet point there, where 83% of foster parents would recommend their agency to others to become foster parents. On this slide, we have some adoption statistics. So you can see where we have currently just over 2,600 children that have a permanency goal of adoption, and just over 1,500 of those children are legally available for adoption, which means that a termination of parental rights judgment has been entered or ordered for that child. There are a few things that we wanted to point out is that there are different types of adoptions. So we have public agency adoptions. So those are foster parent adoptions where DCBS has custody of a child and we facilitate the termination of parental rights and the adoption process. There are also independent adoptions where no agency has custody of a child, and those can include relatives and non-relatives who may seek an independent adoption through the court and through an attorney. There are also private agency adoptions. So private agency adoptions, there are agencies that are licensed just to facilitate adoptions. And those are typically mothers who will seek out a private agency while they are pregnant. And that agency matches them with a home, and then that agency, that private adoption agency, takes custody of that child and then facilitates the adoption process. And then there are also foreign adoptions where DCBS has very little involvement in those, and we also have relative adoptions that are initiated by the relative who has custody of the child.
But just to clarify one thing, Melanie, the stats that you're seeing here on this screen are related to foster care and public children that would be available for public
Public agency adoption or foster parent adoption.
adoption. Mhm.
So here you can see a little bit about the adoption process. So the first piece of any adoption process is that a termination of parental rights judgment has to occur. And we have some requirements. DCBS has some requirements for timeframes of things that occur after that. And you can see here that there is a statute where we provide a presentation summary packet to the court within 30 days. And that presentation summary packet is very lengthy, but it contains information that the adoptive family can have about the child and about the child's birth family and biological family. It also provides that information for the child for when they get older, and if they become an adult, that they may want to seek out contact with their birth parents or other members of their biological family. Other pieces of the adoption process also include a subsidy for adoptive parents that is negotiated, and it provides a monetary benefit for adoptive parents. Federal funding is used to pay for that, and there are some requirements, some eligibility requirements that we'll talk about, I think, in the next slide. And you can see here that the adoption process is largely driven by the court. So attorneys have to be appointed, court dates have to be set. The time frame for finalizing is really dependent on the attorneys involved and the availability of court dates and court dockets. Here, this next slide talks about what I mentioned before around adoption subsidy, and you can see a list there of the eligibility, so what would make a child eligible for an adoption subsidy that would go to their adoptive parents. I will say that this is not an all-inclusive list, so you don't have to have all of these. You only have to have one of these in order to be eligible for a subsidy, and one of those is just that the child is age 7 or older, and they are likely eligible for that subsidy. So DCBS, or the cabinet, covers some non-reoccurring fees for families. Those are largely attorney fees that families may have to, that would be responsible for when they go through the adoption process. So right now, the cabinet covers $1,000, and that is getting ready to increase. It's going to double to $2,000.
Where does that funding come from?
The fees for the attorney's fees. I believe that some of it may be federal. It also may be partially
General funds.
So there is a federal drawdown in these types of cases?
Yes, and subsidies are largely paid for with federal money.
Okay.
Here you can see some statistics about finalized adoptions by calendar year. You can see that the numbers are fluctuating a little bit. In 2023, it does look like that the total number of adoptions decreased a little bit, but we do believe that some of that is attributed to that our overall number of children that are in care or in foster care has decreased. We have less children who are entering care, and so a lot of the children who we have in care are older children, which are generally just a little bit more difficult to find and identify adoptive placements for. Here on this slide, we talk about adoption disruption or adoption disruption supports that DCBS also provides. So we do have some numbers around adoption disruptions, and those are where a family has adopted a child, and sometimes what we see is they may adopt a child when they are younger. A child gets older, they get into their adolescent teenage years, and there may be some behavioral or clinical needs that the family can't manage. So also through federal money, we provide post-adoption placement stabilization supports, also known as PAPS. We do have an acronym for everything, so I will call it PAPS. And between 2021 and 2023, 33 to 46 youth received those PAPS supports. And what PAPS does, it can help, it pays for services to try to meet in-home needs, so clinical needs for that youth, and it can also pay for the treatment of youth who then have to be placed outside of their adoptive home into a congregate care setting or some sort of setting where they can get mental health treatment. Our adoption data per calendar year, I have some of that here. So in 2020, it was 128. 2021 was 198. 2022 was 163. And 2023 was 118. So we are seeing somewhat of a decrease. Year to date for calendar year 24, we are only at 40. So it appears that for 2024, we may see a significant overall decrease in the number of adoption disruptions. Barriers to adoption. So this slide will talk a little bit about what may slow down that process of adoption and what happens. We are seeing an increased number of termination of parental rights appeals. So after there is a judgment entered, the parent, either of the parents can appeal that decision, and we are seeing a little bit of an increase in that, which can make it will stall the adoption process. We have some delays with the courts agreeing to change a permanency goal to adoption and obtaining court dates, and there are also some delays with guardian ad litem reports. So as for DCBS, one of the major contributors to barriers, really in any type of our casework, but particularly in delays in adoption, has historically been our turnover rate. So you could be in the middle of an adoption and a worker leaves, they quit, and they have to get a new caseworker, which will delay the process. So all that I want to say is that right now DCBS is seeing a great improvement in their turnover rates, and right now for the first quarter of 24, we are only at 4%, which is the lowest that I have ever known it to be in many, many years. And we do believe that that is attributed to the pay increases. So we have been able to increase entry-level salaries. We've been able to hire people. We have seen a much more interest. And so it is decreasing that turnover rate. And we are very grateful to both the governor and to the legislator for including those pay increases for us in the budget. I will turn it back over to the commissioner.
Forgot to click from my own slide. So, as I mentioned earlier, we are very excited to announce some changes that we are implementing for our relative and fictive kin caregivers. For the first time, the federal government, our federal partners with the Children's Bureau and the Administration for Children and Families, is allowing states to adopt separate approval standards for relative and fictive kin, meaning that we're looking at ways to streamline the approval process for our relative and fictive kin caregivers. And what that looks like, again, those different standards, and why this is important is because the federal government, along with the department and many of our partners across the state, recognize that relative and fictive kin caregivers don't need the same level of training or scrutiny around requirements that non-familial or traditional foster parents need, and that's because they know the child, they know the family, they're familiar with their behaviors, and oftentimes, most frequently, they have provided care for that child in their home. So here on this slide, it just highlights some of those different standards and what that looks like. Again, the relative fictive kin caregiver often receives placement in emergency situations, so that, again, they're already caring for the child before they're approved as a foster parent. And I think what's really important is to recognize that these relative and fictive kin caregivers are being certified to care for that specific child. So they're not being certified, or they don't have desire to be a foster parent caring for children that are not related to them. And then I already talked about the reduction of the non-safety documentation and the training requirements. And then the benefits of kinship care. I think we all know why it's important to look for placement with kin. We see, when we're able to place with kin, excuse me, we see reduced trauma, improved child well-being, behavioral health and mental health outcomes are better. We see more placement stability and improved outcomes for permanency. And then, of course, preservation of the family and the culture and the community for that child. And so, in addition to the new standards that I just talked about that we are implementing for relative and fictive kin caregivers to become approved as a foster parent, we are also in the process of implementing a new permanency option. And federally, this is known as the Guardianship Assistance Program. But in Kentucky, we are going to call it subsidized permanent custody, and that's because we currently have other guardianship programs, and we don't want the two permanency options to be confused. So in Kentucky, we'll be calling this subsidized permanent custody, but as you can see, 42 states, including the District of Columbia, have already implemented a guardianship assistance program, and as of July 1st, it will be in Kentucky as well. And what that does, again, that creates a new permanency option for our relative and fictive kin caregivers. And it's similar to adoption, but with the major difference being that a termination of parental rights is not required. And here is an overview of the subsidized permanent custody program. Again, it's a new permanency goal for children who are being cared for by relative or fictive kin caregivers. Again, they have to be the relative fictive kin caregiver has to be in an approved foster home, and they have to be in that home for 6 months. The subsidized permanent custody will provide a subsidized monthly payment to the caregiver, and Medicaid will be included. We will explore all permanency options for that child, so return to parent and adoption must not be the appropriate permanency option or for that child before subsidized permanent custody can be explored. And again, the primary difference is between subsidized permanent custody and adoption is that TPR is not required. And this next bullet point is really important because subsidized permanent custody, a contract, must be approved and signed by the cabinet prior to the relative fictive kin caregiver receiving custody in court. So we've been working really closely with our partners with the Administrative Office of Courts. We've been meeting with our judges. We've been providing training within our communities, with our partners and with our staff around subsidized permanent custody and really emphasizing the benefits of this permanency option. And we are receiving a lot of positive feedback and support from, again, our community partners and judges and others for making this permanency option available to our relative and fictive kin caregivers. And then here is just a side-by-side comparison of the benefits. If a relative fictive kin caregiver goes the foster parent route, you'll see what that's on the left, and versus the option of receiving temporary custody and child-only KTAP. So the subsidy amount is significantly higher. If they choose to become a foster parent, they'll still receive the other benefits such as Medicaid, child care, Kentucky KINS, but in addition, those that choose the foster parent route will receive all other additional foster care benefits and supports. And I think that's it, yes.
Okay, thank you, Commissioner and Director. Senator Westerfield, do you have a question, sir?
I did, Chairman. Thank you. Two quick questions. One, I forget how many slides back, but there were, I think, 652 children that were available for adoption, but with no viable adoptive placement. What's being done, if anything, to find a home for those 652 children?
So we have in Kentucky what was formerly known as SNAP, or the Special Needs Adoption Program, that is now CAPE, which is the Kentucky Adoption Program Exchange. I believe we have a lot of acronyms.
It's Profile.
Profile, yes. And we updated really how for these kids that are available that we do not have an identified home for. We have that website now where any person who may be interested in adoption from anywhere in the United States can look and identify a child, express interest in a child and how they could adopt. We are trying to be more intentional, particularly with older children, on how we recruit foster care and adoption and adoptive parents to provide them what foster parents and adoptive parents tell us is really it's around the concern for older children around their behavioral needs and their clinical needs. So we're trying to be really intentional around trainings that we offer to those parents, really trying to involve current foster parents who have fostered older children with that lived experience piece to really mentor foster parents and adoptive parents for older youth. But with those 652 children, we do actively search and look for a home for them, and it can be a nationwide search.
One other thing I'll point real quick. We also partner with the Dave Thomas Foundation, and we have what was referred to as Wendy's Wonderful Kid Recruiters, who work with this population to again do targeted recruitment for homes and or positive adult connections within their life.
What's the pool of people then that the Dave Thomas Foundation does expand that pool, at least in my mind, a bit? But it sounds like you're otherwise relying on people to just find this website to self-volunteer as a possible placement or a home for a child. I didn't know that website existed. So I guess I'm trying to understand the pool of people that you're even able to recruit from at this point. Because is any money spent to advertise or to let people know, hey, Kentuckians, here's a place where you can sign up. If you're not already involved in the system, here's a place where you can do that. I guess I'm just trying to, how do more people find out that that's an opportunity we have for families to serve?
Very good question, Senator Westerfield. Yes, so we do have funding that our federal funding that supports promotion of that website. And we do have it again on different campaigns at different times, promoting that on social media and different platforms. And again, we work and the website is linked to U.S. Kids Adopt, right?
Yes.
Adopt U.S. Kids, sorry. It's also linked to that, so it's nationally, it's not just a Kentucky website. It also links nationally with that website as well. And then again, we our work with the Dave Thomas Foundation and really having dedicated staff to focus on recruitment for those children has been a real success for us in helping find identified adoptive homes for those youth.
I appreciate that. I hate that we have so many that we don't have a home for, and I wish we could give a home for them myself. The second question I had, I don't remember seeing it in your slide, in your deck there, so maybe you did and I just missed it. What is the average length of time to placement right now?
The average length of time to permanency?
Yes, ma'am.
I don't have that. I can get it.
I'd like to know that. I'd like, with Chairman's consent, I'd like the committee to have that information, because there was a time when it was
around 24 months total, and that includes, of course, permanency for us also includes children who are reunified, children who are adopted, children who go to some other kind of permanent placement. We do have those statistics that we can get for you.
I forget where it was, Mr. Chairman, but just a short few years ago, before House Bill 1, I want to say it was 2 or 3 years, an average length of time to permanency.
That's
For I think it was probably for adoption. I think that's about 36 months for adoption. Like Melanie said, we have the average length of stay for each of those permanency outcomes broken down, and we can get that for you.
Hopefully you all can shorten that, because that's too long in any case. Thank you, Chairman.
Okay, members, we're going to run out of time really quickly today. We still have other presenters. I think we're going to take one more question, and if we have time at the end, we'll come back. Next on the list was Representative Fleming, and I apologize to the others who had any questions.
Thank you, Mr. Chairman.
Please be concise.
I will be concise. In fact, this is more of a request than a question. I'm going to follow up with Senator Westerfield's comments. My request deals in metrics. If you can provide a timeline from the start of the process to the end of the process for adoptive as well as foster care, with different milestones on that give me a comparison, not only what it is now, but go back a couple of years ago to see where we are as a comparison. That would give a very clear picture and understanding on how things are proceeding, where the challenges are and so forth. That would really help out. I think will answer his question as well as mine.
Yes.
And it'd be great if you share it with the committee, because that would be very, very fruitful. Thank you.
Yes, we can work on that.
Since that was so quick, Senator Webb.
Thank you. Sort of follow up on Senator Westerfield. I guess I see the horror stories, and I've rarely seen a child that does not want to go home unless it's a pretty egregious separation issue. But the timeline's important to me too, because sometimes there was a time when termination was on, I thought, a too fast track. I worry about the due process involved and what it would be to overcome the permanency, subsidized permanency, if that situation of the parent bettered itself. And would the onus be on them to seek private counsel and disturb it from a civil standpoint? Or is the cabinet washing their hands of that family at that time? Or just what goes on at that time?
So, I'll start and let Melanie finish. But with subsidized, with the permanency goal of subsidized permanent custody, we will be working with that family and supporting that family. And like I said, I think in the presentation, or tried to, maybe I wasn't real clear, but we're going to work with each family and determine what is the best permanency outcome for them. It may be reunification, it may be adoption, or it may be this new permanency option of subsidized permanent custody. So again, we're going to work through that process, really looking at what's in that child's best interest, and then once that relative fifth of kin caregiver receives permanent custody, they'll receive ongoing supports from the cabinet, just like any other foster parent would, which would include the subsidy and other supports going forward.
So the case would not be closed at that time, it would be ongoing to bring it before that forum, or would you have to go to circuit court to disturb that ruling?
If you wanted it to be a change in custody, it would have to come back before a court, in circuit court, yes.
And I think that's important for the committee to note.
Yes.
And flexibility built in is very important from a parental rights standpoint. You look at addiction, you look at domestic violence, those timelines aren't always to the point. So there's got to be flexibility in the system, accountability, but I want to see the cabinet continue in some cases working toward reunification, because like I said, I rarely, in my 36 years of practice, have rarely seen a child that really doesn't want to be reunited if the circumstance would allow. So thank you all.
Agreed.
Senator, I think Judge Pence is on the line here. I think she wanted to weigh in. Judge, go ahead, ma'am.
I might actually be able to better explain how the legal portion of the subsidized permanent custody would work. Permanent custody is already an option that we have to provide permanency. It's great in cases where maybe mom or dad took a little while to get started and they're now in rehab, but we're 2 years into the case. But luckily we have grandmother that we can place with. So we'll give grandmother or relative or someone else permanent custody. And I always explain it like this: permanent is not eternal. Permanent just means right now we are in a dependency, neglect, and abuse case, which is an emergency case. We're going to close this out because we have stability. And whenever mom or dad get back on their feet, all they have to do is file a civil custody case, which in my circumstances, a family court judge, it's all before me. But it would be a circuit court case. They have the burden of saying, okay, I'm done. I completed my case plan and I'm seeking custody of the child. And so the return of that custody is actually a lower standard than going from sole custody to joint custody in a divorce action.
That clarification was necessary, and I appreciate the indulgence, Mr. Chairman.
Thank you, Senator. I think we're going to go ahead and take this opportunity to segue, and we're going to get off the agenda a little bit. And Judge Pence, I think we're going to go ahead and let you proceed with your presentation. Commissioner Director, will you all be able to stay, please, if we have time to get some questions at the end? And Judge, if you would, please introduce yourself formally for the record, and you will have the floor, ma'am.
I am Judge Mica Pence. I am the family court judge in the 43rd Circuit, which is Barron and Metcalfe counties. I have had this position since 2018, so there have been a lot of changes in both government and the way we practice and our use of technology since I took the bench. And I'm basically here today to answer your questions and to provide, I guess, my perspective of the breakdown of where we have delays in the entirety of the process, from the start of a child being removed from the home to that adoption process. I very quickly prepared some documents. I didn't know until yesterday I was for sure going to be testifying today. So last night I tried to kind of make my own rundown of what the timelines are and where I think significant delays are. And I sent those in, but I don't know that I can pull those up. But one of the most useful documents is a flow chart that I sent.
These should be in your folders, members.
And it basically explains every single step of the process to get through termination of parental rights. And this is something that AOC formed. I use it to train new employees here or to assist the clerk's office, because it explains step by step the statute, the processes, the timelines that we have, and even is color coded for the color of forms that we have to use to fill out that step. But just to summarize, the place where I see the most unnecessary delays is going to be that first step of an adjudication hearing. of us getting to the point where, yes, mom or dad have done something wrong. And that is often when you hear the horror stories, to me, that's where it starts. That's where my biggest concerns are, because a lot of times if a child is being abused, there's also going to be a companion criminal case. So we run into this barrier of the counsel for these parents don't want them to testify in family court and then have to proceed in a criminal case in circuit court. It really puts attorneys in a difficult position to protect their clients' Fifth Amendment rights. And it holds things up. I took over a case for another judge recently. It had been 4 years. The criminal case was still pending. There had not been an adjudication in family court. I require that at least the Commonwealth present their proof, because I'm keeping these children away from this parent without the Commonwealth having to present their proof. And I ultimately found that the mother didn't do anything wrong. And she had not had her children for 4 years. And part of that was based on a bond in criminal court because that proceeding had gone on that long. So there's definitely a problem with us trying to manage how quick we try to move in family court with these cases and how slow things move in criminal court, because their goals are different. Their processes are different. Even indictments take longer than our timeline should be totally in family court. So it's just a very different process. And I see a huge delay there. I think that we could improve that with really quality, effective attorneys in family court. I'm very, very lucky, and all but one attorney that I have on my neglect and abuse appointment list have more experience than I do. A couple of them are assistant county attorneys in other counties and then take appointments with me so that they're able to kind of have 2 part-time jobs to make ends meet. But to give you perspective, these cases can go on for 2 years, 4 years, 5 years, and they only get paid $500. The adoption, which is the fun part, is usually around 90 days, and that attorney's provided there are $1,000 provided in attorney's fees, which they just testified will be increased to $2,000. So we've got this attorney who has to deal with someone mad and yelling at them all the time, an angry parent. They're going to have bar complaints filed against them, and we are paying them 1/4 of what we are paying an attorney to do the 90-day happy adoption process. If I won the lottery, I would do adoptions all day for free. And that's where I see our biggest problem being right now. We can't expect a new attorney who's never had a bench trial to prepare for an adjudication on these cases in 45 days. They just don't have the experience to have that kind of turnaround. And my experienced attorneys cannot devote that much of their practice to this. They have to actually make money. They do this for me because they love children and care about our community. I have to schedule around and allow them the opportunity to have other days that they can make money. I can't fast track these cases in the way that I want to unless I don't want any more attorneys on my list. And I do move pretty fast because I do accommodate those schedules. But I had 30 cases on just in a 3-hour time period yesterday. And that's, reviews, trying to make sure we are checking on these children as often as possible. And they're confidential. So little things take time. The in and out of the courtroom takes time, of getting people out from one case and in from another case. Because there aren't just 1 or 2 people on these cases. It's often that we'll have a group of 10 people come in for one case. And it might be because a family has, they're divided, half siblings, et cetera. Could be because we have CASA involved. It could be because there are multiple placements. I had one group of children yesterday that there were 4 different foster care placements because there was a large sibling group, and they all have the right to be heard. And so it takes up a lot of docket time. People ask me how many days a week I'm in court. I'm in court 5 days a week. I jumped on here at 12:15 my time, and I have another hearing at 1. And that's all day, every day, because we do have a lot of timelines in family court. It is probably different when you have district and circuit courts. They have different management of their dockets, but we've seen a huge increase in family court cases and especially domestic violence cases, which again have time limits. I have to hear those cases within 14 days. So the document that I sent outlined kind of those timelines and the steps, how long those hearings take on average, but it's the time requirements and how quick we need to handle some of these things, but in multiple types of cases that we simply run out of docket time to have that big, long adjudication hearing or that full day termination trial. I try my best to block off those times so that we have that available, but there are only so many days in a week and so many hours that I can expect people to show up and still be here. And that's where I run into the biggest problem is, that's a lot to prepare for. An adjudication is an important thing, and a termination trial is a very important event, and they need the time to properly prepare, and they normally want to present evidence for at least a full day. So I hope that you all get to see the documents I prepared because they outline this process and each single step that we have to take and in what time frame we have to take those. And kind of what I see as some of our additional barriers other than that, such as ICPC, getting other states to cooperate and get us the information that we need in a timely manner has been a huge barrier. And the same with using, for example, when we have to have an interpreter on a case, that will delay your case just because you're having to wait. You're having to wait for everything to be interpreted. So the cases take twice as long. I know Warren County has a very large refugee population, so they often have multiple languages and interpreters that they're having to schedule for their hearings. And those are just things that cause delays and make it harder for us to get these cases moving like we would like to.
So you think, as far as the process itself, there's only so much that can be done to streamline. Is it more of a need for additional family courts, or are there things that we can do legislatively to help with these issues, or within your world within family courts, what are the recommendations to address some of these problems?
And again, I've not had a chance to collaborate with anyone else. I was contacted yesterday, and I'm always happy to answer questions and to advocate for children. So I'm here, and so these are just my opinions. I think the first thing is that you have to pay for quality if you want quality in your attorneys. And I think that there have been some push from AOC to try to get that done, and I don't think that we were actually successful in that this year. But that's extremely important. It's not having that quality of counsel. I've seen the difference in practicing in other areas and the struggles that other judges have, and I know how much faster I'm able to move than they are. The attorneys here are going to push, and they're going to push the case even if the county attorney does not. The guardian ad litem will, because they care that much. But they also, again, have years and years of experience and aren't scared to do that. I've been able to do things because I have those attorneys that I know other courts aren't able to do. There are several courts that don't even have enough attorneys to appoint, and so it does slow them down significantly. But when you have someone that's fighting for the child and not just for the rights of the parents, you need a strong advocate in all of those roles to make it balanced, and we're missing that piece. I do think that requiring that TPRs be filed after a certain number of time, after the 15 months, I know that has made it increased burden on the cabinet, but I have seen that make things more effective. And it's not necessarily that we're going to end up terminating rights, but it lights a fire under these parents that they know this is a timeline. This is where I have to make progress or we're done. I think as far as what can be done to support, of course, more family courts would be great. But just increasing the quality is important and making sure we have enough people to address these things. I don't have as many adjudications because I have quality attorneys and they believe them about what's going to happen in court. So they often stipulate. So if you have someone who's not as confident as Meg Alexander in my courtroom, who's been practicing for 40 years, I mean, they're not going to believe someone who's been practicing for 2 years as much as they're going to believe her. And so that means that the parents often stipulate, they get on board, and I'm going to address some of these issues and trying to help move things a little more quicker on our end at our judicial college. I'm speaking about permanency, and we'll try to help with these things. But ultimately, if we had more family courts, that'd be great. But I think that we're doing a lot of the right things and moving in the right direction.
Okay. Judge Pence, thank you so much for being here today and for providing the documentation. We'll go ahead and let you go. I think you said you have to be back in court. And again, thank you so much. Have a good afternoon.
And I'm happy, if anyone has any questions, I'm happy to help. You're welcome to my cell phone number. I will be in Frankfurt for the next 2 days for a training and to record a webinar over the subsidized permanent custody in conjunction with the cabinet. So I will be around and happy to help or assist in any way. Thank you all.
Thank you, ma'am. Senator Adams, you want to go ahead with your question?
Sure, Mr. Chairman. I was just curious as to what DCBS, how they're going to implement Senate Bill 151 since it will be law in July.
Excuse me. So, Senator Adams, as you know, we worked with you and many of the others on Senate Bill 151 during session, and the cabinet is supportive of Senate Bill 151. But during those conversations, and as part of those conversations and development of 151, we also identified that there would be additional funding needed to implement, and that funding was not made available. So at this time, we are still hopeful in the near future that there will be an additional pathway for funding of Senate Bill 151. But without that support, the cabinet will have difficulty moving forward with implementation.
Follow up, Mr. Chairman.
Please.
2 points as a result of your answer. Number one, it is law, so I don't know if it's a negotiable to do it or not do it. I think you have to do it. And number two, there was no conversation or request specifically from the cabinet as to adding funds to the budget. I was told it could be absorbed in your current budget. So here we are. Number one, it will be law. And number two, there wasn't a specific funding request that came from the cabinet. So again, I will pose the question to you, where are we on implementation of Senate Bill 151 when it becomes law?
Well, my understanding is that there was communication about the need for funding for implementation of Senate Bill 151. The cabinet sent a letter outlining, again, the support of Senate Bill 151 before the conclusion of session, and outlining what that budgetary need would be for implementation. So I think, and again, I don't know that we're going to be able to resolve your questions today, but that's currently my understanding of where we're at.
Okay, and I will reiterate one more time that I don't think that this is a negotiable. I think that when the legislature passes a law and the governor signs it into law, then we have to do it. And number two, I can also show you documentation from the cabinet that says that the cost can be absorbed within your current budgetary framework. So I would like a report back, hopefully early July, on where we are on that implementation. Thank you, Mr. Chairman.
And Senator, along those lines, and I can't reference this exactly, but as far as us not funding certain issues, it is my understanding that if we do not fund something from the legislature that requires funding, then there is not a it is not trying to find the right word. Well, it does. They don't have to do it at that point, is what I understand. If we don't fund it, then the requirement as a law, they are not required to follow through with that if we do not provide the funding. That's my understanding, and I may be wrong, but There have been times that I've been through this with legislation where we didn't fund something, and I was told that negates the requirement for the executive branch to follow through. Now, if the other part of it, where if they said they could absorb that I don't know how that would apply. But Senator Merritt, do you have a comment on this?
I do, because my recollection is the same as Senator Adams, that the cabinet said that they could absorb this from their existing budget. And I remember that.
And that would be different.
Yep.
So I completely understand that.
Thank you.
Okay. Representative Baker.
Thank you, Mr. Chairman. My questions, I think, were answered is around the number of kids who are ready to be adopted, but also the timeline from being ready to when they're placed. So I look forward to that information as well. I appreciate the opportunity.
And Senator Webb, do you have one final follow-up? We're going to move on.
Well, the important thing is what is the cost of implementation? Do we have any estimate of that?
Our estimated cost for implementation of Senate Bill 151 was approximately $20 million.
Is there any federal relief or anything we could apply for that would allow to ease the burden of that?
The piece with Senate Bill 151, this would be all general funds to support additional staffing and then to pay for the cost of care for children that would be impacted by Senate Bill 151. Because for us to receive any federal funds, we cannot place the child back in the home they were removed from. The piece of Senate Bill 151, again, these children are in a temporary custody of a relative caregiver, and they have changed their mind and they want to be approved as a foster parent. So the child would have to be removed then from the relative, technically would be removed from the relative caregiver's home, placed in the custody of the cabinet, and then we would place them back in the same home. Because of that makes the child ineligible for federal reimbursement. So it would be all general dollars.
Thank you, Mr. Chairman.
Co-Chair Havard.
Thank you, Chairman Carroll. I appreciate it. I do want to follow up. I will be chairing the July meeting, and so I would like to go ahead and have you all come in to discuss the implementation of Senate Bill 151. As a good refresher for all of us in government, the legislature creates laws, and then the executive branch follows them out. I think this has been a theme of the administration. I also had a bill that somehow didn't have enough money for them to implement it, and so it's not going to be cabinet. That's very frustrating as a legislator. We listen to our people and create legislation. I look out in the crowd right now and see one of my constituents who is has worked tirelessly and does not get paid to do kinship care. And she was so proud of Senate Bill 151 to get passed by the General Assembly. And to hear that it's not going to be implemented because there aren't enough funds when it was stated that the cabinet could absorb the funds is a major problem. And so I would love for you all to be able to come in and share the implementation of that. As a reminder, we're here to serve Kentucky's kids and what's best for them, not what's best for adults or, these are lives that we're working with. And then just one more follow-up. We are always happy to help hand in hand, but it's a two-way street. And so I think that if the administration isn't going to carry out what we pass, that's a bigger issue. And that might be a conversation we need to have the Attorney General come up with an opinion on. If we pass it and you all say you don't have the funding, that's a major issue. So anyways, just take note that in July, you all will be on the agenda to present on Senate Bill 151 implementation. Thank you, Mr. Chairman.
Representative Fleming, quickly, please.
Yes, sir. Thank you, Mr. Chairman. Commissioner, what is your, how many vacancy credits do you have? And what's the value of those credits?
I will have to get that for you, Representative Fleming.
Do you understand what I'm asking? If the senator mentioned that y'all going to absorb it, that tells me that you have vacancy credits, and you can absorb that. You can absorb that process by doing that. Because you're funded for those credits. Thank you.
Representative Stalker.
Thank you. Two questions. One is for you all, but the other one I think more so is for us. What I thought I heard you say in the process when the question was asked about federal dollars and assistance that we might get to help fund Senate Bill 151 was, I'm wondering, is there a workaround for this? Because what I heard you say is this would require us to remove that child from that fictive kin home. That child would have to come back into custody of the cabinet and then would have to be replaced again, placed back with that. So why is that the process, I guess, is a question. And is there a way that we can find a different route so that we do have those federal dollars available to us? That's the first question. So let me let you answer that, and then I'll follow up with my second.
So the children that would be impacted by Senate Bill 151 would be in the temporary custody of their relative, fictive kin caregiver. So to change that custody to where the relative fictive kin caregiver could become a foster parent, the cabinet would have to have custody of that child. So we're not going to remove that child from that. The custody would change on paper from the relative fictive kin caregiver to the cabinet, and we would make the choice and decision to place that child that's in our custody now with that relative fictive kin caregiver. We have asked our federal partners. We have worked with our consultants and others at various ways to try to find a solution that would enable us to receive federal funding for this population of children, and have not found any workarounds or other options available to receive, again, that federal funding to support that population of children.
So I have a clarifying question for you. Am I correct when I'm assuming that when that child was not officially removed from their home by the cabinet and placed with a fictive kin? Is that correct?
So there was a identified safety risk and concern by the cabinet, and that child was needed to be removed from the home. The relative fictive kin caregiver chose to receive temporary custody, not to have the child placed with the cabinet. So for us not to have custody, they chose to receive temporary custody. And then at some point, they are now reconsidering that decision.
Thank you. The second question that I have, I guess, really is for this group is if we cannot find a way, if the money is not there, whatever the conversation was earlier, will be sorted out. But I really just want the members of this committee to think about, at the end of the day, are we willing as a state to absorb that cost, which you said was $20 million is what the price tag would be in order to implement this bill?
Yes.
And I would hope that the answer is yes, because as a former foster parent with the state for 6.5 years, I can tell you that the goal of reunification, when it is safe to do so, is always generally in the best interest for that child. And the more we can do to preserve those relationships with other caregivers from that child's biological family will result in positive outcomes for that child's future. Thank you.
Senator Adams, quickly, and you have the last question.
Thanks. It's just a follow-up, and it's just a clarification for the committee. I know I seemed a little stern earlier, but I will tell you testimony was that the cabinet could absorb it. The governor signed the bill, and then it was after the governor signed the bill that he sent a letter saying, oh, by the way, it's going to cost $20 million, and I don't think we can afford it. So there's a sequence of events that's inconsistent with, I think, how we need to proceed going forward on implementing Senate Bill 151. And I do thank the co-chair for following up on this issue at her July meeting. So thank you very much, Mr. Chairman.
Okay. And it may be that if the governor actually signs a bill, that changes the whether or not they have to comply. So, and I'm curious on I'm sure there's statute that actually addresses that. Because I did go through this past session, but it may be that once the governor signs it, then the requirement to comply is there. So, but we'll do some follow-up on that. Thank you all so much for being here. We're going to move on quickly. The next presenters are with Kentucky Youth Advocates, Shannon Moody, the Chief Policy and Strategic Officer, Cynthia Shevers, Peer Coach Coordinator, and then we have a couple of advocates, Kayla Hatfield and Demarius Jackson Martin. And you all are going to have about 15 minutes, please.
Thanks, Senator Carroll.
And please introduce yourselves for the record, and you'll have the floor.
Okay. We will keep it brief. I'm Shannon Moody with Kentucky Youth Advocates. I'll pass it along to my colleagues here to introduce themselves briefly.
I'm Kayla Hatfield.
I'm Demarius Jackson Martin. I'm Demarius Jackson Martin.
I am Cynthia Sheppers, peer coach coordinator at Kentucky Youth Advocates in True Up.
So really appreciate the time today to present on some youth perspective from foster care and adoption processes, as well as what permanency looks like in kinship care settings. I'm going to skip through a couple of slides here. If you're not familiar with Kentucky Youth Advocates, please find me later and we can talk through who Kentucky Youth Advocates is. Just a quick reminder of what pathways to permanency look like for children who enter the foster care system. So once a child is in foster care, whether that's with a non-relative or a relative fictive kin caregiver, there are a couple of different options for them to get to permanency. And that's what we're really talking about when we're talking about adoption or permanent legal placement with a relative or fictive kin caregiver. As the commissioner had stated, about 75% of young people go either back into the homes with the birth parents or head to a permanent custody situation living with relatives. Another pathway is around adoption and then emancipation. Emancipation is the least ideal option for our young people because that means that they're leaving the foster care system disconnected from any trusted adult. Just really quickly, and you all have this in your packets and we can explain it at another time too, because I want to make sure that our young people have an opportunity to share a bit of their personal experience. What we see in Kentucky and nationally as far as the reasons for exiting foster care, whether it's seeking permanency or getting to permanency and or emancipation, which again is that's the result or the outcome that we do not want to see because we have young people leaving not connected to an adult. So in Kentucky, we see about half of our young people exit to permanency. The other half are exiting to emancipation or another non-permanent option. The reason why it's important to talk about permanency is because without permanency, our young people are at an increased risk of juvenile and criminal justice involvement. They are at an increased risk of severe behavioral health issues. They are more likely to experience homelessness and more likely to become a young parent. With permanency, so having an adult and being in placement and being with a trusted adult, whether that's through adoption or through permanent relative options, reduces the risk of homelessness, increases both physical and mental health, increases the likelihood of post-secondary educational attainment, and then increases the likelihood of having a bank account, which is really important for adulthood as you're entering adulthood. We've mapped out some of the kind of the path to adoption via foster care. I think most folks are familiar with this, and Judge Pence had kind of went through this as well, and it's likely in your packet. This other slide here is showing the pathway to permanency via kinship care. So adoption is ideal, but it's not always appropriate, especially if we have young people being placed with relatives who would like to maintain that permanency, who intend to be a permanent home for young people, but in certain situations, pursuing termination of parental rights is just not ideal for that family. Judge Pence had mentioned sometimes it takes 2 years for parents to really start to work a plan, but we still want permanency for that young person. And what we often see in these situations is young people turning 18, living in permanent custody or legal permanency with a relative or fictive kin caregiver. It's stable. It's a great placement. It's a great option. It's just not resulted in adoption. And we've got a young person here who can talk about what that experience has looked like for them. Kinship and fictive kin placement permanency can look different depending on the options presented here, whether they received temporary custody as discussed briefly, whether they have a goal change to permanent relative placement and utilize the subsidized permanent custody option, which is that middle option, or less likely, but does happen, a goal change to adoption where a relative or fictive kin caregiver would pursue adoption with a termination of parental rights. Again, that's a lot less common. You'll hear from a lot of kinship and fictive kin caregivers that they generally do not want to pursue termination of parental rights in order to maintain the relationship with the birth family. So some barriers to permanency and the transition to adulthood is we know that multiple foster care placements or residential care placement can reduce the likelihood of an adoption or other desirable permanency options. So the more placements a young person has, or if they have experienced congregate care or group placement, they are less likely to get to permanency and are more likely to age out or emancipate through the system. We see often where if there are behavioral health issues that can address and create issues with stability of permanency and placement, underutilizing extended foster care options, so foster care youth choosing to stay connected to the system beyond the age of 18, which can cause instability. And then we do see and have both adoptive parents and foster parents ask for young people to leave their home when they turn 18. So that would be potentially a place to have some conversations around training expectations for our foster and adoptive parents. I'm going to turn it over to our folks to share their experience, and we're going to start with Demarius.
Good afternoon, everyone. My name is Demarius Jackson Martin, lived expert and advocate for those who experience foster care. I come to you today because I have experienced adoption. I was introduced to the foster care system due to my mother having substances in her system while my brother was born. That resulted into us going to foster care, which I ended up getting adopted by my foster parent. Fast forward, as time went by, it started off good, as it should, honeymoon phase. Then that's when the issues started to kick in. Once I really realized I was separated, once the termination of parental rights started to come upon, once I really realized it was the end, this was the final destination, the issues started to arise. The disrespect, the defiance, the disobedience, as far as all of that. And my parent not being able to understand what was going on. She not being trained, she not being taught specifically about what was going on, about what I went through. Having a general idea because you are a foster parent or you are an adopted parent doesn't give you the specific ideas and things you may need so you can raise that child that you have brought into your home. So I say that to say this. I've experienced a lot of neglect due to a person not knowing what other options. So they leave it to other people. They reach out to other people. They may not know what to do, but they do all they can, except asking the person who is experiencing what's going on, how can I help you? So I say that because all of the power was taken away, me not having control over anything and me put in a situation where I had no responsibility of, it kind of leaves you in a space where you're not going to know or you're not going to care where you are in the future. So I say this to say this. It led to a disrupted adoption. Disrupted adoption caused because defiance and disobedience. She felt like she didn't know what else she could do. And she felt like the community she had around was not helping as much as they could. I say that I don't want to bash anyone. I don't want to put a bad taste in anyone's mouth about who these people are. I felt like that they were not properly trained and taught about specific things that I went through, especially race-based trauma. I feel like a lot of foster parents, adoptive parents lack that simple thing. And even if they are the same color, they come from a different background and they was raised on different circumstances. So I feel like as an adoptive parent, as a foster parent, I feel like it should be a curriculum or a training, something that is required for that parent to be specifically trained on the children that she or he is working with so we can prevent adoption disruption.
I'm Kayla Hatfield. I'm 15, and I've been living in kinship care for almost 10 years now with my grandmother. And when I was 5, I was in a home where there were drugs, and the day it was the day before my grandma was going to take me to Disney World, but instead I was put in a car and taken to foster care. I don't remember a lot. I was 5, and if I were to be placed with my grandparents at that time, I would have been better. After I was out of foster care in custody of my grandparents, I struggled going back to school, and my grandparents, they had to go to court to maintain the custody of me, but there was no funding to support that, so they had to get that out of their own account. And if many other kids, they don't get, like, their next of kin don't have the funding to support an attorney or a court fee. And I think that if they had that chance, that many kids would have been happier and wouldn't have had to go into the foster care system. And this is the next page. I had an attorney when I was in foster care, and I don't actually ever remember meeting them. I think that if I were to meet them, they would have known better how to represent me in court. Yeah. And I think that if the system is going to remove a child from their home, they should make sure that the child has what they need no matter what, whether they are in foster care or in kinship care.
Hello again. Although many of you know me as a lived experience expert, I'm actually here to speak on my experiences working with the young adults on True Up's peer network. So there is a lot of them that have a very similar experience to what we're hearing today. Either they did get adopted and they were abandoned, or, they never even got to have any kind of permanency and aged out of foster care. That is what we see most commonly. There was also a young adult I worked with on my housing grant who told me that every day since he was adopted when he was 12, his adoptive family would tell him, when you turn 18, you're getting out of this house. We are no longer going to take care of you. And I think that is crazy because it led him for the next 6 years to just feel really anxious about his future, feel like he had a lack of support. How can he trust these people who, are saying, we don't want you permanently in our life, even though that's what we signed up to do? This young adult didn't have any kind of plan of any kind until he was connected to our housing grant that we're doing that was able to provide him with an emergency hotel stay while he was able to find some stable housing. But I just bring up that to say that there has to be some kind of conversation around, the permanency that is adoption. The goal isn't just to take care of a kid until they're 18, until they're an adult. The goal is to find them some kind of life worth living, whether that be with their biological family, their fictive kin, their adoptive family, or, even if they have to age out, just finding some kind of plan that works for them that isn't any form of re-traumatization, such as being adopted and then being asked to leave at 18.
I think overall, we've spoken to several young people about the importance of permanency and stability as they head towards the age of 18 and as they move beyond the age of 18. There are a lot of opportunities to support young people beyond the age of 18 that is provided through the Department for Community-Based Services and Cabinet for Health and Family Services, but we have a lot of young people who do not elect to remain connected for good reasons sometimes, whether they had poor experience in foster care or maybe they weren't aware of what some of those options are. On this slide, we have some recommendations related to getting to that permanency, some policy recommendations as well as some training or other kind of potential investment opportunities for down the road. But I hope that you hear and continue to hear from young people who have experience in the foster care and kinship care systems, who have experienced adoption or sometimes adoption disruption, to get input and feedback on what they think could be changed in order to ensure that young people have the placement stability that is really needed moving forward. They're just really quickly highlighting Kansas recently passed a law called the SOUL family that allows legal permanent custody without the termination of parental rights at the age of 16. So what Cynthia had said, even if it's not an adoptive parent, there is still an adult that young person is connected to and can lean on in times of, being able to pick up the phone. Like a lot of us were able to pick up the phone, call our parents to ask them how to make sure that the chicken was done on the stove, or ask them how to, navigate different systems like getting a driver's license or renewing license plates. All young people need access to a trusted adult as they move and transition into adulthood, whether that's through adoption, permanency, or some other option. So we're open to any questions if there is time.
Okay. So Demarius, so the biggest struggle you had was just straight ahead up here. So your foster parents and then your adoptive parents, and Shannon, you may know the answer to this. Is there not like specific resources available to, as far as behavioral health, or to make that transition to deal with the issues that Demarius is speaking of?
Yeah, so the Department of Community-Based Services and Commissioner Dennis, or potentially Melanie, was talking about the post-adoption supports. Those are available. I think a lot of folks are not aware that they are available, or they are so far down the path of a disintegrated relationship that they kind of want to give up and don't necessarily attempt to bring things into the home to assess the issue or get behavioral health involved. I don't know if you, Demarius, had experienced post-adoption supports.
We didn't experience no post-adoption supports. I don't think they was getting advertised. When I did get adopted, it was around 2013, 2014. So at the time, I don't think being adopted was like, I don't think it was a big thing to do or support afterwards, because all the support was there prior to the adoption. After the adoption, that's when everybody left. And that's when things went bad because there was no supervision.
So did you just eventually grow out of all of that, and obviously you've come a long way from what you described. Just maturity take care of it in the long run, or?
It took a lot of therapy. It took a lot of therapy.
Okay. And Kayla, in your situation, you feel like there was just not complete planning before decisions were made on your complete future, I guess, and looking far enough down the road when decisions were made, and then not resources for your grandparents to be able to take care of the legal issues.
Yes, that's it.
Okay. All right, very good. Senator Elkins, you have a question, sir?
I have a question. I also want to say thank you to Shannon Moody and the advocates. Thank you also, Mr. Chair. Thank you to the advocates. Thank you to Demarius and Kayla for sharing your stories. I appreciate that very, very much. I want to go back to, though, Senate Bill 151, and when the DCBS is invited back next month, I would really like to understand better the process why a child needs to be removed from a home and then replaced in a home. At first, I think we heard that had to happen, and then we heard it only happened on paper. I'd like to know, is that policy? I'd like them to be able to address, is that policy? Is that statute? Is it federal policy? Is it federal statute? Because if it's policy and it's not federal, it's something they can change. If it's statute, I think it's something we can change and maybe get some of those federal funds. I would also really like to know or better understand the need for $20 million to implement Senate Bill 151 and what that $20 million will be used on. Thank you, Mr. Chair. I appreciate that.
I can see that there are probably going to be other hearings on this topic, and it is a very important issue, and a lot of work was gone into that. And, just this whole issue, I think we may need another committee meeting during the interim. Representative Co-Chair Heverin, you have a question.
Thank you. It's more of a comment, Chair. I just want to take a minute and thank you all for coming and talking today. It takes a lot of courage to come and talk in a bunch of old people, me specifically, of course. No, it really does take a lot of courage to come to the Kentucky General Assembly and talk, and I greatly appreciate it. I think so many times in Frankfort, and several of the committee have heard me say this, we decide what's going on and we make policy from that, and we don't always listen, and that's something I appreciate. I believe a few of you have been to my office before. I know Shannon's been great about setting me up. I've heard from parents. I've heard from you all, because I think it's so important to hear your lived experiences and us be able to make policy off that. So thank you. And Ms. Hatfield, I have no doubt that your grandmother is so proud of you. She is a moving force in kinship care. And a big reason why this is the kinship care, why we're so frustrated about Senate Bill 151 is for Norma and for you. She's done a great job advocating and sharing your all story with all of us here. And I actually do have a question. I'll be very brief. Mr. Chairman, is Shannon, I would actually be really curious, Ms. Moody, if you knew about the struggles with Senate Bill 151 from the cabinet and the money required.
Just to speak to my own experience, obviously, Kentucky Youth Advocates is very supportive of Senate Bill 151, see a very clear need for that time for grandparents, other relatives, fictive kin to make that very important, lifelong, impactful decision on whether or not they choose the temporary custody route or moving into a kinship foster care option with those additional supports that come along with kinship care. That also sets the stage for subsidized permanent custody. So if you think about the two decisions or the decisions that are made there, if they choose the kinship foster care route, they would then be eligible for subsidized permanent custody, which would last until a young person is 18, unless for some reason they are no longer in care. So we are very supportive of the implementation of Senate Bill 151. I was aware of, conversations about potential costs. I was under the impression that those were resolved, but I also am not in the weeds and not always in those rooms when conversations are happening. I would be happy to creatively problem solve for whatever needs to happen in order to make that a reality, and would be pleased to have you all continue to look into that.
Thank you, Shannon. I greatly appreciate that. I didn't mean to necessarily put you on the spot there, but I know that you have been very active. KYA has been very active in the kinship care conversation, so we also like to touch base with stakeholders. And I hate that DCBS rushed out and was not able to hear you all and your stories. They really missed out on a great presentation. Thank you, Mr. Chairman.
Thank you, Co-Chair. Senator Webb, last question.
Thank you, and thank you all for coming and shedding light on some things that I talk about all the time, and that's the bad experiences and the problems that we have with rapid placement and disregarding a perfectly good caregiver, family member, fictive member that could take that child at the onset, and the cabinet turns a blind eye to that sometimes, and only complicates and adds trauma to that individual. And I've seen it for years, and this is not an isolated case. These are not isolated cases. And that's always been a problem for me. And I think sometimes the programs and the funding mechanisms that are set up to chase numbers and to have easy outcomes like post-adoption, adoption's a lot of times a glorious day. It's a great day to participate in. Sometimes not so much, but then it's over. It's the easy route. You chase an adoption, get that child in a placement, and then you're done. So I think we chase numbers, we chase criteria for funding, and we chase easy sometimes. We have to concentrate on the outcome of the kids. And when we sit here and talk about these issues, and our budget is our priority, and if we want to fix some of these things, whether it's, I work in one closed county that doesn't have a family court. And it's a mess. It's hard to coordinate these dockets, like the judge said. And I practiced in Barron County, too. So, had DNA cases there. So, it's a universal issue. But if we want to put our money where our mouth is and solve some of these problems, we will prioritize funding. And we will have family courts. We will pay legal representatives an appropriate amount. We will fund legal aid. Legal aid handles a lot of this, and every year we try to cut them. So we've got to bolster the support systems that these children have and concentrate, sort of like reentry and corrections that we talk about and never do. We've got to put money in post-adoption and in the Senate bills that we pass. And I think, whether it's incrementally or whatever, we've got to make this physical priority, and we can help a lot of these problems, not just by throwing money at it, by doing it in a very surgical manner and appropriately, and try to get rid of some of the obstacles. And a lot of them are federal, and we're chasing money that way. So we've got to evaluate that in that light, and that's my physical comment of the day. Thank you, Mr. Chairman.
Representative Decker, quickly, and then we have one more presentation, and it's a story that I really want you all to hear.
Thank you, Mr. Chairman. I'll be quick. I operate a homeless shelter for women and children. A few years ago, we started taking 18-year-old girls who had aged out of foster care because they had nowhere else to go. And now high schools will call us if there is such a problem. I have a question about they had been adopted and there were problems, just as you all have talked about. And I think you said that you had some legislative suggestions. I'm wondering if you all who have lived this, you all who are working on this, have a list of things that could have helped in that situation. In every case we've had, the child wanted to stay, was told as soon as you turn 18, you're gone. It was shocking to them, and eventually they were. Maybe one came out on the front porch. What would have helped in that situation? What did you need? If KYA has thoughts about what would help in those situations that the state could provide? Thank you.
It would be a community around adoptive parents, a community around foster parents. If they feel like they are alone, they're not going to feel like they can do it. I think what played a big role, and my foster parent, my adoptive parent was married. She was married, so it wasn't like it was a single household. It was another parent. So I know that 2-parent households wasn't the answer to it. So it was like, okay, you need support from somebody who clearly understands and knows your situation. So I feel like a community based around adoptive parents and foster parents would help.
Thank you.
I would also just recommend that when we are identifying potential adoptive parents, making sure that they understand that that ideally is for eternity. That ideally is well beyond the age of 18. When you are a parent, you are ideally a parent until the end of your life. So I don't have a policy recommendation on that. I think it's just making sure that our adoptive parents are aware that that is the expectation.
I would also like to add that I feel like, if possible, that DCBS or whoever is initiating that adoption is following up with not only that family, but that child on an individual basis and saying, what's going wrong, what's going right, is this still working? And I think that in a couple of the situations, I know that would have been really helpful.
Mr. Chairman, thank you. And I think it was shocking to me to learn it's not just foster care that ends up that way, but that it's adoption. So thank you all for that. Thank you, Mr. Chairman.
Thank you all for being here today, and thank you all for being willing to step up and tell your stories. We appreciate it very much. One final presentation. Jennifer, if you would please come forward, and I'm going to butcher your name, Jennifer Sacharnoski Nelson. Is that close? Good. Okay. And Jennifer, if you would, please introduce yourself for the record, and you have the floor. We have about 15 minutes. Yeah, can you check your mic? Is the green light on? Yeah, could you, if you don't mind, just go ahead and sit down and pull it closer to you. Yeah, it still doesn't sound. Yeah, push.
I do have a problem pushing buttons, though. So that checks out. My name is Jennifer Sacharnoski Nelson. I am a small-town lawyer from Princeton, Kentucky. But that's not what I'm here to talk to you about today. I'm here to talk to you about my children. I have 3 children, 2 adopted through the system, and I was absolutely amazed at all the presenters that went before me because I do GAL work. I do adoption work. I have had foster children before I adopted mine. I've been involved in the PAPS system. I work with DCBS every day. So, and I was told with my issue to call Frankfurt. So thank y'all for answering and letting me speak today. I really do appreciate it. 4 big issues that I wanted to discuss. One is the disconnect between the laws, the regulations, and the cabinet policy. 2 is the local level experience that I have had. 3 is the coordination between the branches. They talk about post-adoptive services, but we also have RNC workers and permanency teams, and there is a disconnect there. And 4 is a biological relative search. And I know some of you are aware of these things because I know Representative Stalker, I believe, said she had foster children, and I know other people here have been attorneys and are attorneys, but some of them it is acronym soup. So my daughter, Eli, I'm not trying to disrupt. I don't want to get rid of my daughter. I want her better. She has serious mental health conditions. She has maybe schizophrenia, maybe bipolar, maybe. What we've done through our local regional mental health is a medication roulette at this point. It's very difficult. Making it more difficult is she has a very low IQ, 42. And for those of you not in the mental health field, that means we count to 10 about 60% of the time correctly. You have a lot of trouble diagnosing that type of behaviors and mental health. Putting that all together with someone with an intellectual disability is very troubling. So I wanted to get her into a residential facility because she is wonderful for the first couple days. Anywhere. She would meet people, and she can be my best kid. She can. And she is some days. But it's going to take a while with mental health to figure out what's wrong. What I found out, though, is as a mom and as a lawyer, I can't just go check my kid in for mental health services. That's not how it works. We went through everywhere in Kentucky. I reached out to the PAPS program because they're supposed to be there for post-adoptive services. They applied to every residential facility in the state. We were rejected by every residential facility in the state. This began in August of last year. In April of this year, I went to Vanderbilt after she had an issue at school. More violent behavior. She's a great kid. I put some pictures in my packet that I put together yesterday. I want her home. The permanency goal for us is her and her brother and her sister. Hopefully, they can have tiny houses on the farm and they can live out their days. We're working on estate planning, but they have to get better first. She has to get better first. But I found out you can't just check them in. You have to go basically through a social worker to get there. I also found out they don't really know how to do it. Because I would ask, well, who do you have to call? Regional office? Okay, who are they going to call? Frankfurt. So I'm here. I don't know if y'all got called or not. but I don't think they are trained properly on how to make those calls. And I don't think they're trying to make it harder. I think they're trying to do their jobs, but I don't think they really understand how. For example, our KRS law here said that mental health services shall be provided, and we shall have post-adoptive services. I was told they needed 4 rejections. I didn't find anything about 4 rejections. Any laws that y'all made, any of the KARs, I didn't find it until we get to policy. That's the cabinet policy. And I think they are trying to implement, but there is a huge gap between the laws over here, the regulations over here, and their policy. And then even inside their policy, how that gets taken down to your local level. They had no idea how to do it. Even today, I don't think they understand who they need to talk to make this happen. We ended up having to file a dependency action on our own. I filed a dependency action against myself so that the cabinet would have to do it. They would have to take custody. And they were given legal custody in April. She just left for Maryhurst on June 5th. We had her the rest of the time. So talking about custody, the cabinet had custody of my daughter for 60 days, and she didn't leave home. So that's a term that we throw around a lot here, and I just wanted to clarify for some of y'all. I did have a letter from child support in the mail, though, within a week, them asking us to have pay our child support. I said I would happily write a check as soon as y'all find a place to put her for a little while. That's been hard. The other big topic that I wanted y'all to hear about today was the biological search. We went to court. We've been dealing with PAPS. After there's a disposition where they say the goal of the child, the goal in our case is return to parent with a goal of getting residential mental health treatment. That was the goal. About 5 days after that goal and that final order came out, letters went to every one of my family members, every one of my child's father's family members, and all of my child's biological family members who have never met this child. We took Eli home from the hospital. I swaddled her the day she was born. And someone, somewhere in Lyon County, in Caldwell County, got a letter saying, our records indicate you may be related to, there's her name, there's my name, there's my ex-husband's name, her date of birth, and her biological mother's name, all in one letter addressed to everyone who may be related to her in the counties. There's a law in the KRS that says they're confidential. There's a policy at the cabinet level that says we're going to send letters to everyone. When I asked who sent the letters, they said Frankfurt. I do not believe that there's someone here pushing a button, sending those letters. I think somebody has to initiate that contact. And as to what we can do to solve it, I would propose that in order to do a biological relative search, you have to get a court order. That should be implied based on the confidentiality of the adoptions anyway, but it's not, because their policy says to do it. And it's troublesome as a mom, as I'm in the system, as a advocate. I advocate for my clients. And that are moms, dads, children. It's hard for me to work in this system and then be told by the system that the computer did it, because I don't believe we're computers. And I think we should have a little more thought in the process than it's just part of the process. And I did not write a whole lot out. I thought there might have been questions, and I'm usually not good at staying within a time frame. So let me see if there's any, threats. There are innuendos, not necessarily blatant threats, but my belief is that we are going to have fewer people going to PAPS and going to social services for help when they are threatened with child support or threatened with you could lose the rest of your children. I had no problem telling a social worker at Vanderbilt that I was not worried about my children being taken away. But when they told me we were discharged and that I should just take her home now, I said no. And she's told me that that would be neglect and abandonment, and they were going to report me. And I said, well, go ahead. I've been working with them for 9 months now. They did report me. I had to go through an investigation. It was unsubstantiated, so the system worked there. But if I was not aware of the system, if I did not have the resources behind me, and if I had a reason to run, I would have ran from that hospital, and I would have never reached out for any help. And the people that are most vulnerable are the ones who are going to get hurt. And that's why I'm here today. So, I included in my presentation a personal timeline. Hopefully it will get better for her, but there is a void for children with special needs, children with these behavioral issues, and post-adoptive services, although they were very, very sympathetic. 9 people on a Zoom call at one time. I don't know what they did. I liked them. I like them. They were great. They offered me peer support group. But we're in groups all the time with Special Olympics and all kinds of other. I don't need more friends. We needed doctors. And that is what I'm asking for consideration today is residential facilities, access to mental health residential facilities, some coordination of services, and for please someone introduce something to say that they can't go and ask everybody who's ever been a cousin. And the letter even said, or if you know anybody, a teacher, a church member, anyone who may like this child, please call us. If we could do something about that, I would appreciate it. I wanted to take a moment, though, to also say how impressed I was with the young people that just came up here. They were wonderful. And being on this side and hearing their side, very impressive young people. So I can keep talking if anybody doesn't have any questions.
Jennifer, I can tell you that during the past session, there were numerous meetings regarding treatment for mental health issues for kids. And the focus was primarily on DJJ involved kids, justice involved kids, but it went over into cabinet because a lot of times, and you know this, we're talking about the same kids. Mm-hmm. And there are things starting to happen in that area where more providers are becoming more willing to expand their services and to grow their services, grow their facilities. And so we did see some progress in that area, and that's working with the Kentucky Hospital Association, with Health and Family Services, with the Justice Cabinet, with the Administrative Office of Courts, and some processes that were set up in a bill that didn't make it through the House. It made it through the Senate, didn't make it through the House, but even though what we were focusing on was more DJJ, the net impact would have affected the entire system, and it still will. Those things are still moving forward. So I think there is some progress in that area that's going to lead to more services, special to kids with special needs. I have no doubt that will be part of it. But I do understand, the struggles that you have having a child with special needs, and having to drive to Alabama to pick her up this last week because a flight was canceled.
Yes.
She couldn't quite handle that. So I do get that, and but know that those talks are being had, and we are making some progress in the number of facilities, the number of beds. And your story is a reminder that we need to have more conversations for our kids with special needs and making sure they're included in as we're planning those services. Any other questions from the committee? Okay. Senator Webb, go ahead.
I appreciate you being here and bringing light to some of the issues that we deal with. Not only we do that in the far east Kentucky too, so those issues are statewide. And I've literally stood in a client's driveway and been threatened with arrest because they called the sheriff because of policy. Wasn't the law, wasn't in a statute or regulation. And you dare them. I'm like, please take me, because this needs to be brought to light. So I think we need to just kind of go through, maybe those of us who practice that, and find some areas and try to address it even statutorily to make a clear remedy. And it changes a lot of times with administration or interpretations. And it's hard to represent your people and them to know the rules when that happens. So I think that's something we need to look at, Mr. Chairman.
Okay, very good. Jennifer, do you have any closing comments?
I did appreciate the request and the receptiveness that y'all, on a different topic, that on guardian ad litems and guardian ad litem work. I do a lot of that work, and it is important work. And there are some good people and good social workers, good courts in Western Kentucky, and I think they're doing everything they can. So thank y'all for letting me talk today.
Thank you for being here. Appreciate it very much. The next meeting of the Interim Joint Committee on Families and Children will be Tuesday, July the 30th at 1 p.m., and we will be in this room. And if there are no other issues before the committee, we stand adjourned.